Hello everyone. Can you guys hear me? Just type yes on the chat screen. Amazing. So guys, I welcome you all once again to our another session of Ask My Mentor. Due to some technical glitch yesterday, we need to reschedule the session today. So I again welcome Advocate Gagan Gandhi today with us. So Gagan Gandhi, who has done his graduation in mathematics and statistics from St. Stephen's College, completed his management from Faculty of Management Studies, University of Delhi, started his career initially with American Express in their Risk and Information Department before he decided to do law from Faculty of Law, University of Delhi. As a legal expert, he is also an expert in research and drafting. This has been proved by reading his papers published by Emerald, which are also taught as an example in various research subjects. He has research paper on social and environmental disclosure index in Journal of Advances in Management, and also case studies on activity based costing titled as KK Metals CNC process costing, and on vendor selection and vendor rating titled as Bharat Tobacco. He is the managing partner of NitiNyaya Law Offices, which deals with cases of check dishonor, probate, succession, partition and possession, recovery suits, commercial suits, service matters, writ petitions, and many more. Apart from pro bono litigation, he is also known for detailed drafting of contract. So without wasting much of time, I hand over the screen to Advocate Gagan Gandhi.
Yeah, hi everyone. Very good afternoon to all of you. First, I would like to thank you all for taking time out of your schedule during this tough situation. And I thank Lloyd and Sahil for giving me an opportunity to interact with all of you participants on this subject which is very dear to me, and subject which carries forward, which is the foundation for any case or for any dispute. So if we have the good foundation, we can prevent a lot of things, as we are going to understand during the course of our interaction. So why the contracts, or how the contract should be drafted, what are the essential ingredients one should keep in mind. So these are some of the facets which we would cover during the interactive session. And since the lockdown has begin, everybody has started digging out his contract, which became oblivious in the past. The reason for that is that everybody is searching for what is the legal obligation, or how I can, how much I have to discharge my legal obligation, how much I can escape my legal obligation in these financially tough conditions, as well as conditions which prohibit the normal functioning of the businesses. So in the light of these facts, we are going to discover that how a properly drafted contract could save everybody from the difficult situations. Yes, sir.
Hello.
Yes, yes,
Hi.
yes.
Yes, Gagan. So just to start with the initial conversation, I like very generic question I would like to ask you: what is a contract and how it is so essential for students, startups, and corporates?
Yeah, any agreement which is enforceable by law becomes a contract. Now, before we proceed, we should know what is an agreement. An agreement is something, if I give you an offer and you accept that offer, then it becomes an agreement. And if suppose it is that is followed by a consideration, that it turns into a contract. Now, what happened yesterday, I give an analogy that all the participants, if you would have charged them for this webinar, they probably might have sued you for the damages. Now, in the absence of any consideration, they could not have done so, because that was only an agreement which could not have been enforced by law. So just to set the tone for everybody, that is the difference between an agreement and a contract. So mostly people are mistaken between a contract and an agreement. So all contracts are agreements, whereas all agreements are not contracts. Now, why it is essential for the startups, especially corporates, to have the contract? So an agreement could be a feeling which one may not obey, or which one may not follow. So hence it becomes an essential to have a contract, so that there is a proper legal discharge to it. So that in case what was required or what was expected out of the other party, if that is not committed or if that is not performed, then the party who is affected has the option of a legal remedy. So that is why it becomes essential for, especially for the startups, especially for the corporates, to have contract, since they have high stakes, and in order to have a risk mitigating factor also to keep in mind, it is prudent to have a contract in place before proceeding for any financial transaction. I hope it answers, Sahil.
Absolutely, absolutely. So Gagan, another thing I would like to start with. So as you know that there's a the Indian Contract Act which we have been taught in our law schools, and
Right,
where we were like told how an agreement can become a contract. But when
right.
it comes to the practical implementation, a lot of people found it different and include some flaws in it. Can you put more light on it?
Yeah, actually, that is the reason why we start finding flaws in the agreements which turn into a contract, is that when we do not have our terms and conditions specified in that contract. The terms and conditions should be certain. The contract has to be between two parties. The parties should be competent. For example, if I'm entering into a contract with Lloyd and if I am representing NitiNyaya, then I should be competent to represent NitiNyaya. Then only you can enforce that contract. Then the contract should have a legal objective. What is the objective behind two or more parties entering into a contract? Then there should be a free will. I should not be forced by Lloyd, or I should not have an undue influence to enter into a contract with Lloyd. It should be the free will of both the parties, or more than two parties who are entering into a contract. That's a multi-party contract. Then the intent behind those parties who are entering into a contract should be to establish a legal relationship. Now I will come to that. That suppose you and me enter into a contract where you ask me to smuggle some goods which are prohibited, and you also agree, I also agree to provide you those goods. But then that will not take the nature of a contract, because there is no legal relationship which is being created between two of us. So these are some of the facets which one should have in mind before drafting of a contract. And that is a reason, when you don't have these binding factors in mind, then one starts getting into the flaws of the contract. I
Okay,
hope
okay.
it has answered.
Absolutely, absolutely. So, as Gagan, we have a community of law students, startups, corporates attending the session with us today.
Yes, yes.
Can you put some light on what essential things they have to keep in mind when it comes to drafting of contract?
Drafting of a contract, it should, first of all, you should have clarity of clauses. What I mean by clarity is that there should be no ambiguity once you are drafting a contract. What you are expecting, what obligations you want from the other party, it should be very clearly laid down in that contract. Similarly, it holds true for the other party. Whatever expectations or legal obligation they are expecting from you, it should be clearly, without any ambiguity, mentioned in that contract. Then you should have short paras, You should not go for long paras while drafting a contract. You should, if you have more points to be illustrated or to be incorporated, then you should increase the number of paras. Because longer the paragraph is, it gives you more opportunity for the interpretation. So, in order to avoid multiple interpretations, one should have shorter paragraphs. Then there should be a structure that one para should flow from the next para. So there should be a
Okay.
flow of various clauses in that contract. Then there should be certainty in the terms and conditions of for the performance of the contract. That whatever terms and conditions, whether that's a rent, whether that's payment time period for the payment of rent, and how, when it will be paid, by whom it will be paid, all these things, it should be clearly mentioned in that contract. And then lastly, it should be clearly laid down what is the legal recourse that both the parties agree to adopt in case of termination of a contract, whether they want to go for an arbitration or whether they want to settle it in the court. How they want to settle, it should be clearly laid down. Then you
Okay.
should have a penalty clause in case of non-performance of the contract. What is the penal provision? That should be clearly mentioned. So that is to actually, the purpose of the contract is to bring all the possibilities which may arise out of that particular business transaction on a piece of paper, so that there is no swaying of feelings as we move ahead in the relationship. There could be a possibility of a fixed time span for a contract. Then that time span should be clearly mentioned in that contract. These are some of the
Okay.
factors which one need to keep in mind while drafting a contract.
Amazing, amazing. So, Gagan, as you know, the current situation of COVID-19 pandemic has brought force majeure into the limelight. Everyone is talking about the force majeure clause. What's your take on it?
Force majeure clause, which once became, uh, once nobody remembered that there is such provision as force majeure, it has actually become on the, it has come on the forefront. And the reason is big lockdown. The reason is COVID-19 pandemic. And this force majeure clause is actually borrowed from the Roman law. This is not an Indian concept. I will. The Indian concept of the same clause is actually frustration of contract. Now, what actually is
Okay.
force majeure is when, due to impossibility of the performance of the contract, the affected party decides to terminate the contract. Then they rely upon this clause. That there are three options which the affected party can exercise. That could be, one could be termination, second could be suspension, third could be reformation or restructuring. The parties can enter and renegotiate the terms and conditions. Now, this clause actually is being misused by some of the parties, taking advantage of the current situation which is prevailing outside. So it has to be dealt on a case to case basis whether that clause actually can be invoked or not.
All right. So, as you talked about frustration of contract, what is frustration of contract?
Frustration of contract is actually, it actually flows from section 56 of the Indian Contract Act. This is for those who are students of law or who are
Okay.
practitioners of law. So this actually is a provision which makes the which frustrates the objective of the contract. Let's say uh, this event was supposed to take place offline,
Right.
right? And we entered into a contract before the lockdown started. Now, this lockdown would make the contract between me and the lawyer as being frustrated because of the conditions prevailing outside. So that is what is meant by frustration of a contract. So anything which prohibits you, which hinders you from either from for either party to discharge their respective legal obligations.
How is this gonna affect the industry?
Industry is going to be affected in a bigger way, where in terms of payment. Now you have an
Okay.
employer and employee relationship. Now, employer will take excuse of this provision side, saying that I am not in a position to pay you the salary, and I am invoking this. And the essential ingredient actually of invoking this clause is to serve the notice on the other party. So the employer will serve notice on the employee saying that I am financially incapable of doing it. Hence, I will not discharge my financial obligation. So uh, actually there is a underlying difference. The contract, if it becomes burdened, then it does not mean that it is a force majeure clause. For instance, in this case, the employer, whether he is actually financially incapacitated to pay the salary or not, that has to be seen. Simply invoking this clause that since there is a lockdown and since there is a closure of business, it does not mean that it prohibits him or it hinders his financial obligations. So that is why it has to be seen from a case to case basis. So I would like to rely upon a recent judgment of Bombay High Court, where actually the party who is importing steel from abroad, they approached the court. They said we would not pay to our supplier because of this lockdown condition. Since the goods were already supplied, they were lying at the shore, the party, the importer, was not willing to discharge his financial obligations. So the court said, sorry, boss, nothing doing. Steel is an essential commodity. There is no prohibition from you in discharging your financial obligations by distribution of that steel to the respective vendors. So hence, you cannot rely or you cannot invoke this clause just like that. So it depends from a fact to fact. Like on the contrary, in the Delhi High Court, in the recent judgment in the case of Halliburton Services versus Vedanta, the High Court upheld otherwise. Halliburton entered into a contract with Vedanta for drilling. The Vedanta invoked the bank guarantee clause, saying that since you have not performed your obligation by the due time, hence we will invoke your bank guarantees. Halliburton approached the court invoking the force majeure clause, saying that we are incapacitated, we are prohibited from actually carrying out the drilling activities because of this lockdown. Hence, they should be this invoking of bank guarantee should be stayed till this lockdown is lifted. So one has to look into the facts of that case to decide whether this clause can be invoked or not.
So I was doing a research few days back, as you also mentioned about employer and employee relationship and the disputes arising. So I've been reading a lot of disputes which has been arising between employer and employees and tenant and landlord. What is the main reason behind this? Is this due to the current lockdown situation, or there is any other reason behind it?
No, one is actually the genuine concern. Genuine concern could be when the employer is not in a position to pay all his employees the salary. One thing is that. Same thing holds true for the tenant. That if you have tenant who whose major earning goes into the rent, then he would not be in a position to discharge his financial obligation. But if we look at the legal aspect of it, the legal aspect actually talks about that this clause force majeure, I'm linking this to force majeure because in these two relationships, majority of the affected parties are relying upon this clause, either this clause or the frustration of contract. Now, employer, in order to evade the financial obligations, they are actually not paying the salary. There is a notification also by the MHA which talks about the payment of wages. So then there is a confusion actually that whether that notification is applicable to the salaried employees or they are only applicable to the wages or the workers, which is still pending, which is still sub judice before the apex court. The other kind of litigation which is going around is between the landlord and the tenant. The tenant is asking for a rebate, is asking for a bailout package from the landlord, saying that since my shop was closed, my business was closed, I could not perform my business. So hence, I should not be allowed, or there should be restructuring of the rent between the landlord and the tenant. Again, then it will depend from a fact case to case basis whether actually the tenant is cash rich, whether the tenant is actually in a position to discharge his financial obligations or not. or is it just that he is taking an excuse of this lockdown condition not to discharge his financial obligations?
Okay. So now suppose Gagan, there's like just a question struck in my mind. Suppose an employee is leaving the company in this current pandemic situation of lockdown, the COVID-19, and having the very crucial data of the company. Can that employee be stopped from moving on from the company for the time being and bind him or her with some sort of contract or any agreement?
You mean to say that an employee is having a confidential information of the organization
Right,
and he
right,
is interested in moving out of the organization, right?
right.
So in that case, the all the exit formalities, I would call them exit formalities, should be completed so that employee hands over the crucial data which he is carrying, and the employer discharges his financial obligations by way of reforming or by way of restructuring the contract between employer and employee. That would be good for both of them in order to avoid further litigation.
But as you know, with that right now we all are at our home. We might not
Yes.
able to submit all the confidential information in hand. So, like, is there any way we can stop that employee from moving out of the company?
No, if you can, if the employee puts in his papers and you accept that resignation, then it implies that you have actually discharged the employee from the organization. So what the remaining formalities, keeping in mind that there is no sharing of that confidential information, or there is no leakage of that data, that can be decided. And the other option which could be decided is to encrypt the data which the employee is having. If that can be worked upon, then it will, then there need not be a situation arising from that, that the employee may leak out that data of the organization.
Okay, okay. So, I just wanted to ask like another question. Like, what is a contingent contract?
Contract is flows from section 32 of the Indian Contract Act. It talks about happening of a pre-event before the actual event takes place. I give you an example. Like, I am, let's say, a mask manufacturing unit, and you are supplying me the cloth for the mask manufacturing. Now, when I will receive cloth from you, I will be able to manufacture the mask. So that is a contingent. My delivery of or my production of the mask is contingent upon you supplying me that cloth, which is an essential ingredient for the mask manufacturing.
Okay,
I hope it answers.
absolutely, absolutely. So, can you explain when everything is present, but there is no lawful object?
When everything is present and there is no lawful object. Oh, you mean to say, what do you mean by when everything is present?
Like there's like every clauses like present in the contract,
Right.
but there is no lawful object.
Okay. Okay. Suppose both of us enter into an agreement
Mhm.
to murder, let's say, our competitor. You also agree, I also agree, and then there is a consideration also. I am supposed to discharge my obligation, but the object is actually unlawful in this case. So that is what is actually meant by when you have everything else in place. You are competent to enter into a contract. I am competent to enter into a contract. There is free will present there. There are two parties there. Then you have certainty of terms and conditions. We have decided the exact amount which will be paid to me for murdering that competitor. But then the object here is unlawful.
Okay, okay. So what are the things to keep in mind while drafting a contract?
This I have discussed during the
Right,
start of our discussion. Uh,
absolutely, you discussed it,
at
but
this
this is a question which we have, which is being raised by the audience itself. So what do you think, like what they should actually keep in mind from a student perspective? If you can just clear us out from the student perspective, startup and the corporate perspective,
yeah,
individually.
Yeah, at the risk of repetition, I would say while drafting a contract, one should keep 4 or 5 things in mind. One thing is that there should be clarity of the clauses. The clauses which I'm going to mention in my contract, it should be very clear. There should be no room for any ambiguity so that it is not subjected to multiple interpretations in order to avoid future litigation. Second thing in mind is that there should be certainty of terms and conditions. Now, for example, in case of a contract between a landlord and a tenant for a startup, let's say startup has hired a place and they want to enter into a contract with the landlord. Now, how much rent has to be paid? When the rent has to be paid? uh, what are the obligations of a landlord? Will it take care of housekeeping? Whether it will exclude electricity or not? What in case uh, the startup does not end up paying rent? Then what will there be any damages for that or not? What in case the landlord does not upkeep the building? Will there be any damages for that or not? What if both of them enter into a dispute? What will be the legal recourse for them? Will they enter into an arbitration, or will there be out of court settlement? How they're going to decide the dispute between them? So these are some of the things which they would like to keep in mind while drafting a contract.
Okay.
Then the important factor is actually that you should not go for long paras. I've seen contracts having long paras, the repetition of words, redundancy of clauses, so that should be avoided so that the person who is reading it actually makes out what is there in the contract. Then important thing is that your one clause should flow from the previous clause. So there should be a link between the two clauses. Like you have a first clause of payment of rent, then you immediately jump to something of, let's say, the obligation from the point of view of landlord. Then it is incoherent. There should be consistency in the flow of the contract. So one clause should be flowing from the previous clause. So these are some of the factors which they would like to keep in mind. When actually it will depend on case to case basis. This was an example for a landlord and tenant. You may have different clauses in case of commercial contracts. You may have different clauses in case of an employer and an employee.
All right. So, keeping in mind from case to case basis, what is the remedy for an affected party in case of breach of contract?
Now there are two remedies which could be available to any affected party in case there is a breach. First is that they can claim for damages. The other thing is that they can ask for the specific performance. Let's say the audience or the participants who registered or who logged in yesterday, suppose they were charged fees for it, then it would have been a contract. Now there was a breach of contract. I would not go into that. There was a frustration of contract. Let's say there was a breach of contract and you decided not to hold the webinar yesterday. Then the participants could have actually sought their money back from you with interest, or they could have asked that, sorry boss, we want webinar, so you kindly hold it on some other day. So that's specific performance of the contract.
Okay, okay. Like this was a live example question, like live question and a live example. Amazing. So, just to start, like just another question. What are the types of damages? This is specifically for the law students who are attending. This is really helpful for your, and especially the first and second year law students. What are the types of damages?
Types of we have three kinds of damages. One is liquidated damages, which most of the times, and I would recommend that people, the parties entering into a contract, should actually specify those damages. For example, uh, lawyered, and I give at the risk of giving the same example, let's say lawyered and the participants enter into a contract, and it is explicitly mentioned that if we are not able to hold the webinar, we will pay you the your fees plus, let's say, some component as the damages. So that is predefined, pre-decided between both of you. Then
Right.
comes actually the compensation. Compensation is that it may lead to somebody not somebody's, let's say, if a crucial component of some supplier is not supplied, then it may lead to multiple losses. So then the supplier has to compensate the person buyer for that purpose. If, let's say, in case of ventilator, in case of very crucial component, if that is missing, then you have to actually compensate the other party, which you may not be able to decide before you enter into a contract. So that is something which has to be computed by the loss which has incurred by the other party. And the third kind of damage is actually the punitive damage. By suppose any party fails to discharge his obligation, then there will be a cost or the punitive damages that has to be given to the other party.
So what is the difference between void and voidable agreement? Contract, I mean.
Void contracts are actually no contracts in first place. They are void ab initio, which we call. Ab initio means since the beginning. So let's say you and me enter into a contract to kill our competitor. That contract would be a void contract. And
Okay.
voidable is something which becomes later on, which a party can cancel at a subsequent stage. Let's say in case of misrepresentation, in case of fraud, then if the party comes to know of that fraud, then the party who is affected can actually terminate that contract. So that becomes voidable at the option of the party who is affected. Let's say if I enter into a contract and you mentioned that the dispute will be subject to Delhi, and later on when I receive a warranty certificate from the supplier of the goods, I find that in case of any problem or in case of any difficulty, then I have to approach Italy from where the goods are being supplied. So then I can actually, then that contract becomes voidable at my discretion. I can cancel that contract because I was misrepresented by actually entered into the contract.
Okay. Okay. I mean, this was the most confusing question in my first year of law. Frankly speaking, I could not understand void and voidable contract, the difference between them. So, so like as you know, the current situation of COVID-19 and the force majeure, I just wanted to ask you before, if like COVID-19 will be covered under force majeure, even if the pandemic has not been mentioned, whether COVID-19 will be covered under force majeure, even if pandemic has not been mentioned.
Yeah, that's a very good question, and actually, NitiNyaya has received a lot of queries with respect to this question,
Okay.
and I think it's going to benefit the participants also.
Right.
Whether the word pandemic is being used in the force majeure clause or not, it becomes irrelevant because government of the day has already declared COVID-19 as a force majeure event. So that event has to be force majeure. So since this COVID-19 has been already declared, so there remains no contention whether that force majeure clause would be invoked with respect to COVID-19 or not.
Okay. Okay. So, all right. I mean, there are a lot of things, but like due to this COVID-19 situation, and like some things are good, and mostly things are bad, of course. From the legal perspective, this is a very generic. I would like to ask you from the legal perspective, how lawyers are suffering, how the legal professionals are suffering due to this.
We are suffering. We are suffering left, right, and center. Actually,
Okay.
reason being that the courts since 16th of March they are taking up urgent matters, urgent, and that too very on a very I would say bail applications or most of the PLs with respect to COVID-19. So the entire work, the other ordinary course of litigation has come to an halt. So,
Okay.
and secondly, the litigants also have lost confidence because of the health risk involved by approaching the courts. So that is the another aspect of COVID-19 which has affected the lawyers. Third thing is that most of the lawyers who are actually not retainers, they earn on a case-to-case basis. So those and majority of them belong to that category. So that has affected to a large extent those who are actually
Okay.
not retainers to big companies.
Right. Okay, so as you know that we have an audience, like I'm sure the journal councils who are attending the event with us today, they must be very much aware of this. But the young lawyers or the students, how important for them is to do a contract and drafting specific course, a certificate course or diploma course for them. How important it is for them.
And COVID-19
As
has
you know,
actually,
as you know that the colleges do not teach that practical, implementations of contracts, the clauses and everything. They might have the contract and drafting subject in their third or fourth year, but they
right.
might not have the practical experience of doing it until and unless they have done the internship with a very good lawyer, right? But now, suppose they get an opportunity to do a course and intern with that particular lawyer in
Right.
that, like while doing the course, how benefit it will be for them.
You have actually rightly put it, and with due respect to all the law colleges, I would also second you on that aspect. That we hardly share the practical implications of a contract. What we end up actually is few provisions of the contract, and then some case laws on that contract, which, if we enter into the real world scenario, would not help us to that extent. So in that situation, it becomes inevitable, I would say, to have a special course on the drafting of contract, because contracts have were in the past also significant, and now after COVID-19 they will become much more significant, because people who never looked upon what was mentioned in the contract are now, I think there would be no lawyer who has been called to check whether what is the legal obligation on my part or what is the legal obligation on the part of the other party. So it would become very important for organizations, for startups, to have structured, well defined contracts with respect to their business transactions, so that the litigation could be avoided to the extent possible. Any good contract, I would say, can save you litigation. I would say penny wise, pound foolish. We may save upon few rupees by not having a contract or by not getting the contract drafted in the manner which it should be drafted, which may lead to the dispute. The dispute actually is with respect to the interpretation of the clauses, with respect to the omission of certain clauses. So if we have, for both the parties, I would not say about that one party is having everything being taken care of and the other party is being not taken care of. So in the interest of both the parties, I would say, if their financial obligations are mentioned in the contract, then, or if their other obligations are mentioned in the contract, then they could save their time of the court. So
Okay.
it's important for the law students actually to go for internship or to go for such kind of certification. Or maybe the
Amazing,
law
amazing.
schools can, or maybe the law schools can decide to have such certifications alongside their main paper.
Law colleges or law schools might not do that. I'm sure they must have tried. I don't know, but since I have done like my 5 years of law, I
Yes,
could not see that. I could not see that, and I don't know. You have done your 3 years LLB, right? So
correct, correct, correct.
have you seen that from Delhi University? Was it
No,
there?
no, no. I hope my teachers are not there.
Of course, I'm sure. The faculties have always put up this thing, but
Yes,
due to the because of course the higher management, higher authority sometimes not allow. There might be
right.
numerous reasons about it, but I mean we don't know. We don't know the in depth of the management system of the university. So
I
yes,
think that is why internship becomes very important.
very
And
true.
actually, lot of things, lot of nitty gritties of the contract, I learned it while on the job. So how you fraud, concepts like fraud, frustration of contract, these actually, otherwise it will become academic concepts only. So in order to
Right.
comprehend them practically, one needs to have the hands dirty.
So the session was an amazing session. So we have numerous questions from the audience. So I'll just take each question one by one.
Sure, sure.
So the first question is, suppose two advocate friends have decided to practice together as
Right.
partners. What
Right.
should be the prerequisites for contracts between them?
Oh yeah, that's a very interesting question. uh, they, they should decide that what could be the bone of contention between them, that who will share profit sharing basis. They can decide that who will take how much amount after deducting the expenses. Then what kind of cases would the each partner be engaged with? Let's say there's a matrimonial case, it will be between the two advocates. I do not know how they allocate the work. So a work allocation should be predefined, I would say, in order to avoid any conflict. Then they could decide who is good at drafting, who is good at arguments. And they may decide before entering into a contract that okay, you will take care of evidence collection, I will take care of drafting, or we both will do it. It will depend on how both of them are comfortable uh, dealing with that allocation of work. Then clients, let's say A brings the clients and B is not able to bring any client, then how will the profit sharing take place? So these are some of the things which they may keep in mind before they enter into a partnership.
Okay, I hope this clears the answer for the question. So there is another question, sir. We have seen agreement to sale is always suppressed by sale deed. Can you
Suppressed by?
explain some sales deed?
Okay, yes,
Sales deed.
yes,
So
yes.
can you explain some circumstances where agreement to sale is enough and no need of sale deed is required?
Suppose after an agreement to sale, the party decides to not part with the property, then the affected party can actually have two options, which I discussed earlier also, which is one is damages, to seek damages, the other is to seek specific performance. And that will uh, depend on the market condition, and whether the party is interested in now performance of the contract, or they are the object of the contract is frustrated. Let's say there is a change in the there is a change in the pricing, then the party may take a call accordingly whether they are interested in damages or the specific performance.
Okay. So this is one very interesting question. Someone is actually challenging the courts basically, as the courts are not properly working due to the lockdown. What
Right.
remedy the party has for the breach or frustration if the court is not taking non-essential matters?
Yeah, you cannot be prejudiced by the action of the court, I would say that. So they cannot do anything about it. They have to wait till the courts start functioning normally.
Okay. So, but I guess the courts are working digitally nowadays. I mean,
They are working,
on
but not to
over.
the extent where that participant would be
Of course,
expecting,
of
since
course,
there are
of
only
course.
urgent matters which are which are being taken up by the courts. And at
Right,
district court
right.
levels also, the situation is not that very bright with respect to video conferencing. So
I
he
mean,
might be,
we should have actually adopted this very long back, but
yes,
now the situation is so. I hope
yeah,
everyone is gonna get into this.
yeah, at least one can have an arbitration proceedings if one can invoke that.
True.
If that arbitration clause is mentioned in the contract, then actually that would be much more easier to have that through video conferencing
Right,
with
right.
as compared to the court proceedings.
So there's one another question. Sir, can you tell about Qazi contracts, Benami transaction, and estoppel?
Okay, a lot of things in one question, I guess.
Yeah.
Uh, I start with estoppel. Estoppel is uh, when, based on my representation, you alter your position, then you cannot come back and say you cannot come back and change that position. Suppose I represent that okay, I am son of so and so. Now in another proceeding I cannot say that I am son of Y. So if I have taken a position of that I am son of X, then in a subsequent or in any alternate proceeding I cannot say that I am son of Y, because based on my representation that I am son of X, all the legal heirs of X, they have aligned themselves accordingly, and then the distribution of assets have had already taken place accordingly. Now I cannot go back and say, or I cannot eat my own words and say No, boss, it was a mistake. I am son of Y. Now I start claiming the properties of Y also. So that is what is meant by estoppel. So it flows from section 115 of the Indian Evidence Act. The other part which you were asking was Benami transactions.
Benami
Benami
transactions.
transaction. Benami transaction is something I I buy something on behalf of Sahil in the name of Sahil, but although I invest that money, right? So that's a Benami transaction because actually the money has not come from Sahil. The money has come from Gagan for that particular deal or for that particular transaction. So that is called as Benami transaction. And the other thing which you were, if you can repeat that, side, what was the other
So
aspect?
quasi contracts.
Quasi contracts.
Right.
Okay. So contracts which are not, I would say, not. I have to check that actually, Sahil, that what we mean by quasi contracts.
Sure, sure. So for that question, we will have the answer from Advocate Gagan Gandhi and will send back to you. So another question is, drafting a contract has a wide area.
Right.
A lawyer cannot always know the contingencies that can happen in the event. How to deal in such situation?
Yes, that's very practical aspect of it. Fortunately, unfortunately, one has to deal with it. One has to contemplate all the possibilities that could arise, and the biggest support would be the previous contracts or the contracts which exist on that same subject matter. So one can draw from those contracts, one can take help from those contracts, that okay, this contract has actually covered all these possible clauses, so I can incorporate or I can borrow the best sharing practices from that particular contract. Otherwise, both the parties have to sit down, they have to brainstorm that okay, if X happens, then what I should do. If Y thing takes place, then what is the remedy? So all possibilities should be covered by that brainstorming discussion. So that is the only way out. We can eliminate the possibility of any dispute between the parties, or keeping taking care of all the possible situations which may arise. Now, let's say COVID-19. Nobody expected that COVID-19 would take place, but still, all the contracts are being taken care of by actually the government by declaring it as a force majeure event. And even if the contract is silent on force majeure, then you can rely upon frustration of contract. So
Right.
sometimes the law helps you in case if you have missed on any clause or if you have missed on any factual position, then the law is there to help you out.
Okay, so talking about dispute, there's one question. I don't know every disputes that can be raised for contracts to sell drones. What's your light on it?
To sell drones,
Yeah.
if you can please make it more clear what is meant by that.
I mean, there's one statement by Mohawk. So it's mentioned. It says that I don't know every disputes that can be raised for contracts to sell drones.
That is
So he
not clear
want
to me.
he so Mohawk, can you just provide us with the clarity to the question? That would be really great. So I'll just switch to another question. So
Sure.
A and B buy a land together and they
Right.
signed and notarized a MOU as to
Right.
the division of land among them.
Right.
Conditions mentioned in the MOU, if violated, does it act as a breach of contract? And can other party be sued?
Provided there is consideration with when they actually entered into that agreement. If there is a consideration, then that's a contract, and yes, you can sue the other party for the breach of contract.
Okay. So this was very quick. Very in a one line. The question was very long. So this is a very interesting part of law, I guess.
So,
So
most of the people actually, the reason is that since I belong to a mathematical background, so I
right.
usually answer my queries in one line or two lines only.
But that's
Perhaps
good. That's good actually.
so. Perhaps that helps me in litigation as well, I guess.
Amazing. That's quite amazing. So I mean, this is a very new term for me, being a law grad. I mean, explain the boilerplate in a contract.
Boilerplate.
Yeah,
I have not come across that. Even
same with me.
I have to search for it.
So Shishir, we will definitely get back to you with your answer about boilerplate. So after the research, we'll share the answer with you. So okay. So another question is, but when one party denies to perform his or her part, then we can file a suit for specific performance.
Yes, there are two options.
Mhm.
Depending on which option one would like to exercise and depending on the facts of that case. So both the options are not, I would say, optionable. One would actually weigh more than the other option. So one should
Okay.
decide it actually prudently, that one is whether one is interested in claiming damages, seeking damages, or whether one is asking for the specific performance. So that one has to take a call on that.
All right. Okay. So I hope this clears your answer. So one another question: what are the clauses that are to be put in a contract?
It will depend on what kind of contract you are entering into. If it is a
Right.
landlord and tenant contract, the clauses would be different in nature. If it's an employer and employee contract, then the clauses would be different in nature. If it's a contract between a supplier and a buyer, then you will have whole lot of different clauses to safeguard. So there is
Right.
no one standard pattern or some standard format for having the clauses. But broadly, which I have already shared, that you should keep those things in mind while having a contract.
So, sir, another question. Can you explain the difference between frustration and force majeure, as both talks about freeing or obligation?
Oh yeah, that's a very good question. Uh, First is the conceptual background to it. Force majeure is not Indian concept. Force majeure is a Roman concept, and whereas frustration of contract is an Indian concept, since it flows from the Indian Contract Act. Now, the event or the accident which happened yesterday with respect to this webinar, this will come under frustration of contract and not force major, because your objective got frustrated of holding this webinar due to a number of reasons. There was no war, there was no riot, there was no natural calamity, there was no act of God. So I would not consider it under as a force majeure event. I would consider it as a frustration of a contract where the lawyer became incapacitated or it was prohibited from discharging its obligation of entering into of conducting this webinar. And this frustration of contract flows from section 56 of the Indian Contract Act.
Okay.
So
So,
in cases where you do not have force majeure clause mentioned, then one can rely upon frustration of contract.
okay. So, but as you mentioned about the we could like lawyer could not provide as we could not conduct the webinar yesterday, but this was due to the technical glitch from the Zoom
Yes,
main servers. So,
yes.
how Zoom will be liable in that situation?
Zoom, yes, that's a very important aspect of it. It will depend on what is the agreement, what is the contract between Lloyd and Zoom. That whether
Mm-hmm.
Zoom actually can take alibi of this clause or not. You can seek
Okay.
damages, Sahil, and
Right.
we will give you all assistance for that.
Definitely. But I touch wood, none of them has sued us.
Okay.
So thank God.
No, no. The reason being, it was not a contract in place. First instance,
Absolutely.
that's
Absolutely.
the reason. I
So
hope
what is
it
the
has
diff? Absolutely, absolutely. This has cleared. I am sure this has cleared the answer question. So, what is the difference between contract and tenders? Can you please explain it with example? And what are the provisions for acceptance and withdrawal of tenders?
right. That's a very good question. Tenders, suppose you have a suppose government has a project, they float tenders for that. And tenders, they invite bids, financial and technical bids. You apply the bids, and then depending on the criteria mentioned in that, they choose the highest or the lowest bidder depending on the situation. So once that bid is chosen, that particular bid is chosen, then that tender actually takes the form of a contract with the bidder who is finally chosen or finally selected. So, and what was the second part, Sahil?
Second part, what I'll just tell you the second part. So the second part is basically the provisions. What are the provisions for acceptance and withdrawal of tenders?
Okay, okay. So you have a they mentioned you about a date that okay, we will accept all the bids till so and so date. Then you then the bidders who have actually applied, they applied till that date, and before that date actually they have the option to withdraw that bid, because in case that bid is selected, then you would be awarded that tender, then you will be asked to discharge your obligations under that contract. So that is how the bid takes the form of a contract.
Okay.
Bid is
So
actually an open process. Contract is between a closed. You have parties decided beforehand. In bid, you do not have parties decided beforehand. You may have bids
uh,
from 10 number of people, 15 number of people. You do not know who is going to bid for your tender. But
right,
yes, you know, you know who is going to whom you are going to have a contract with. So that's also another major difference.
right. So I hope this clears your question. So I would take the last question, and then I'll just do some announcement for further session and an announcement of collaboration with all of you. So the question is, if there is a contract between two parties at the time of marriage, that in any case the parties go for the divorce, the husband have to give maintenance according to that contract. And at the time of divorce, he disagrees to that contract, then what would be the procedure?
You are talking about prenuptial contracts, I guess,
Right.
which is not there in India. So I guess the participant would be interested in would be giving an example of somewhere else. So because in
Mm-hmm.
India the marriage is a solemn affair, you don't have contracts for marriage. But
Right.
however, in case if we it will depend on the that law of that particular country, that in case of breach of that contract, what are going to be the ramifications of it, or in case they have mentioned about the, as I mentioned in my earlier discussion, that whether they have mentioned that what will be the damages, whether they have defined the damages or not. So it will depend on that, and if they have
Okay.
not, then you may seek compensatory damages also.
So I guess we should not talk about divorce here right now, because the current pandemic has given a lot of such situations in the
Right,
news.
right, right.
So the session was an amazing session, Gagan, and we are very thankful that you joined. And
Thank you.
really apologize to you and everyone for the last day due to the technical glitch. So, in case we could not answer your queries to larger extent, we would request you to provide your queries in the discuss section. We will share the link with you, and Advocate Gagan would be most happy to provide you with all the answers. Okay,
Yeah.
and
Thanks, Sahil.
okay, so you have something to share.
Yeah, I will be sharing about in case they have further queries, or if due to
Hmm.
paucity of time, if we are not able to take up all the questions, then they
Okay,
may write or give us a call at this number. And I hope that participants found it to be a productive and informative session.
definitely. I'm damn sure about it. I'm damn sure about it. And also, Lloyd has collaborated with Analian, which is the leading legal edutech platform. So we have a course on contract and drafting, and also we are providing you with a guaranteed internship. The one who would like to take that course will also get a, like few students will get guaranteed internship with Advocate Gagan Gandhi as well. So also
Yeah, yeah,
let us know in case you're looking forward to that those courses, and definitely will provide you with the internships, and also the startups or general counsels who would like to get in touch with Advocate Gagan Gandhi. Feel free to note down his number or reach out to Lloyd. Our operations team would love to connect you with him.
yeah. That's
Thank you
nice of you,
so
Sahil.
much.
We would love to have interns on board. NitiNyaya is looking
Absolutely.
forward to the same. And once again, I thank Lloyd and Sahil, you especially, for organizing this webinar and giving me an opportunity to interact with
It's our pleasure
students,
to have
lawyers.
you.
And
It's our
believe
pleasure to
me,
have
I'm
you.
not the same person who entered in the webinar. So it has improved me in this 1 hour.
Thank you so much, sir. Thank you so much, and we are obliged to have you, and looking forward for more such sessions. And in case of any queries, feel free to contact us to Gagan Gandhi directly or partner us plus students at lawyer.in, and we'll definitely get back to you. Thank you so much. Thank you,
Okay,
guys.
okay. Bye.